They don't go for so like that. And within the university system, no, I must place the union in proper pathway for people to understand.
Hello and welcome to the program. Nigeria Senate President's quest to stop the country's Code of Conduct Tribunal from trying him on allegations of false declaration of assets has suffered yet another legal setback because the Federal High Court in Lagos, Southwest Nigeria, on Friday dismissed Senator Bukola Saraki's appeal challenging the jurisdiction of the tribunal to try him for corruption. Saraki, who is facing a 13-count charge of false declaration of assets when he was governor of Kwara State, had actually appealed to the court to stop his arrest by the police and stay proceedings before the Code of Conduct Tribunal. Now, the presiding judge in that case, Justice Ibrahim Buba, ruled that his court did not have jurisdiction to entertain the application. The Senate President had wanted the Federal High Court to stop the Code of Conduct Bureau and Tribunal from prosecuting him on the grounds that it is only the Attorney General of the Federation that has the power to initiate criminal proceedings against him. He pled not guilty, of course, to all the 13 charges leveled against him by the Code of Conduct Bureau, describing them as false and frivolous, and that the charges were basically calculated to rubbish him. On Thursday, that was last Thursday now, his legal team worked out on the Code of Conduct Tribunal after the tribunal chairman refused to stop the trial, pending the outcome of Saraki's appeal before the Supreme Court. Now, his lawyers had argued that the tribunal ought to have stayed action until the Supreme Court gives a verdict on that appeal. And now, of course, the tribunal turned down that argument, prompting one of Saraki's lawyer to describe the action of the tribunal chairman as judicial rascality. Joining me now to analyze what actually happened at the Code of Conduct Tribunal last Thursday, and of course this whole trial of the Senate President, is Malaki Ugumadu, who is of course the national president of the Committee for the Defense of Human Rights, and of course is a lawyer. Malaki, thank you very much for joining me on the program.
Thank you, DEJI,
first
for
of
this
all,
opportunity.
let me get your reaction to that drama we saw. It's not the first time. We remember before Saraki appeared before that Code of Conduct Tribunal, it took a lot. As a matter of fact, the tribunal had to issue a warrant for his arrest before he eventually appeared before the tribunal. And of course, we saw his lawyer initially arguing that, you know, the tribunal had no right to try him. And now, this drama last Thursday, the lawyers to Saraki walking out on the tribunal and saying, look, the tribunal ought to have waited for the Supreme Court to decide on his appeal before going ahead.
Let us start from the known and then proceed to the unknown, just so that we could rationalize what is playing out, if it is within the bounds of rationalization. Otherwise, a lot more persons who are cynical and who have lost confidence in the whole process and exercise will insist that it has become a bizarre, an absurdity, one that was conceived in treachery and nurtured in mischief. Now, the claim of the lawyers, this time very senior
lawyers, senior advocates of Nigeria,
is that the trial judge ought to stay proceedings pending the determination of the appeal at the Supreme Court. Now, I am sure that even law students in the law school are aware that a mere notice of appeal does not operate as a stay. A mere notice of appeal is a notification that an appeal, if entered, is pending.
What you're saying now is quite surprising, because we heard one of the lawyers say, for instance, in his 35 years as a lawyer, he had never seen anything like that, where a tribunal chooses to go ahead or a lower court chooses to go ahead on a case that is pending before the Supreme Court.
Mark my words, I said that mere notice of appeal in law does not operate as a stay of proceedings. That notice ought to be moved and the application for stay granted because before you have a stay. Now, most often than not, what persons who are desirous of manipulating the judicial process, what they do is to watch carefully, monitor the trajectory of the proceedings, find the most convenient point, usually on preliminary points of law, and then proceed on appeal by merely filing that appeal and abandon it there, in the hope that once that is done, you bring an application urging the court to stay proceedings pending the determination of that appeal. My contention is that that mere notice does not operate as a stay. When was that notice of appeal filed? By the records we had, it was filed on the 3rd of November. So as it is, a date has not even been given. Now, assuming without considering that a date has already been given, will that now completely twist and frustrate the criminal trial of the Senate President within the precincts of the Administration of Criminal Justice Act, which is an act of the National Assembly? Do not forget that the whole philosophy, underlining the enactment of the Administration of Criminal Justice Act, which came into effect on the 13th of May 2015, is to ensure speedy dispensation of justice, particularly regarding criminal prosecutions. One in which some of the sections expressly insist that trials shall be on daily basis, just so that, and it leads to so many other things, including the congestion of prisons. But let us even move further and look at the issues involved. One, no person in his right senses would deny the fact that Senate President Saraki enjoys his constitutional right not just to fair hearing, but presumption of innocence. In other words, he is deemed innocent until he is proved guilty. But you know what? In saner environments, in other civilized democracies, civilized world, by the time a man has been charged to court, beyond indictment, beyond allegation, beyond charges, arraigned for criminal offenses bordering on issues of integrity, issues of transparency, issues of dishonesty, what naturally follows, don't forget I entered the caveat in civilized crime, is that they withdraw, they retreat.
This is a civilized crime, but it doesn't happen here.
Well, let's take it by your words. And I don't know what other factors determine a civilized society if those variables don't play out. Now, but rather than retreating, he has run to the Federal High Court, as your intro clearly emphasized.
Exactly.
He has run to the Court of Appeal.
A Federal High Court in Lagos, a Federal High Court in Abuja, Appeal Court in Abuja.
And those are... Now, the poverty of the situation, which is already taking away the shine from the sail, and then shortchanging the Nigerian people, and exposing us more to the conspiracy of the ruling class, is unholy collaboration, support, solidarity. But
because each time he goes to
member, most members
each time he goes to the tribunal, the Senate doesn't sit for that day. We saw that the last time.
Now, we're inundated with days of recess, days of vacation, days of holidays. We're also aware that under the Constitution of the Federal Republic of Nigeria, the Senate is expected, indeed mandatorily expected, to meet at least 181 days in 1 year. Now, in all of these days when the Senate closes and comes to a halt, we still have the Deputy Senate President.
Exactly.
That one is not under trial, at least as of today, even if there are potential. Now, what happens to his functions? To what extent can we afford, as a country in a dire state, deserving of quality representation, quality legislation, and quality oversighting? Because these are the three cardinal responsibilities of the legislature. But above all, the legislature is expected to moderate the excesses of the executive by these identified functions. So, why then did we have a Deputy Senate President?
Let me just come in here. Perhaps, I mean, you just
you
go to Kenya and see
what is other members of the senators as members of the ruling class and ruling political party? What are they telling the Nigerian people? That for as long as one of them has been fingered, but I can tell you there is a reason, it's not far-fetched. The truth is that if we don't fight this battle to a standstill, virtually all of us will go down. Because it is just that Saraki has been clearly identified as one who will face trial on this. Virtually all of them. So we must go beyond the legalese. We must move beyond the frontiers of their permutations as presented and ascertain the undercurrent waters that informs their behavior, their disposition, and their attitude.
It's actually scandalous that the Senate would shut down business for the day each time the Senate President was going to appear before the Code of Conduct Tribunal. It's akin, it's just like saying what happened to Uhuru Kenyatta in Kenya when he was going to The Hague for, so the whole government in Kenya should have just shut down. But what exactly does it say to us as a people and as a government that an entire Senate would shut down?
Well, I'm very happy with this question. And I'm happy I am invited here, not just as a lawyer, but as the president of the Committee of the Defense of Human Rights. What this presents is that it is not yet Uhuru. We are not yet in the promised land. What this graphically paints and insists is that we must return to the trenches. I was actively involved in the democratization process leading up to the emergence of this present government. But you know what? We have so soon seen that we need to do a further check, because increasingly it has become clear that the Nigerian people actually need an alternative to the ruling class. Please mark my word. APC, PDP, ABGA, and all of those belong to a single political class. It is for this reason that even the Saraki, even the Amechis, and so on and so forth, did not find it difficult whatsoever to transmute and cross the eyes from PDP to APC. My friend, Bamidele Aturu of blessed memory, used to ask me, we have to look deeper. If any of these people mounting the change mantra is confronted to give to the Nigerian people or even to themselves what their policies are on privatization, you will not hear anything different. At best, it will be semantics around the core factors that exposes them at having the same policy. Lies are better told in English. But at the end of the day, they are saying precisely the same thing. So, the Nigerian people succeeded in one, defeating the culture of impunity, breaking the jinx that seemed as though an incumbent government or party cannot be removed. To that extent, there was victory. But to the extent that we will maximize the change that occurred towards the turning around of the fortunes of the Nigerian people, that is greatly in doubt. And therefore, we are going to look inwards. First, appreciate.
Because I really want to know what we can do.
And I'm making the point.
Yeah.
We must appreciate that even the organs of... First, there is a contradiction in thinking that the same government that is tainted can have the capacity to confront its own problem. I'll give you an example. EFCC. EFCC is an agency of government expected to tackle corruption. But the contradiction we have seen over the years is that a government cannot effectively confront its vices regarding corruption by its own agencies, no matter how independent they claim to be. What is happening in NDLEA? I have had cause to confront the present chairman of NDLEA to point out to Nigerians how many drug barons he has prosecuted and punished in this country. I'm not talking of Koreas.
I understand, but I still
you
want
go
us
to
stay,
custom.
I still want us to stay on this Saraki issue. I just want to know what exactly we can do to prevent these senators from shutting down the Senate each time the Senate president was going to appear before the Code of Conduct Tribunal. Because, look, we're still going to see more of this. I mean, Saraki is still going to appear before that tribunal. And it means if the trial was going to last for, say, 2 weeks, you know, it means the Senate would be shut down
under the Constitution. Please, I will break it down so that people don't think that we are still wallowing in that illusion that these things are practicable. Under the Constitution, the people of Nigeria, from their constituency, can recall the members of their representatives. Does it happen easily? No.
No.
What then do? We have to resort to the people themselves. I'm talking of the civil society organizations, the media, the labor, all other segments of the society that are the direct victims of this whole drama. And say, we have to clearly insist on our representatives there to face the business of legislation.
I don't get it.
Now, if they don't, we have to organize. It can be a campaign issue that the Saraki judicial trial should assume a life of his own, but have him attend to his allegations. While we deal with the business of governance through the legislature. Secondly, the constituent members of each constituencies and senatorial districts must be able to put across a demand, extract a demand from their representatives.
Yeah.
And say that this is becoming a huge distraction. As we speak today, a couple of states are overtaken by flood, ecological issues.
We don't have the Senate making
no
pronouncements on that.
No person is bothered about that. On the contrary, what we are beginning to hear is that they are pushing and the Revenue Mobilization and Allocation Commission is listening to them that there is need to review their salaries upwards. Now, when that is done, don't forget the real sovereignty of Nigeria resides in the people. What has always been missing is that the people are not sufficiently organized to extract the minimum.
Because it appears we are not quantifying the man hours they lose. We're not quantifying in terms of naira and kobo.
Again, and I commend the judges, both at the Federal High Court, Justice Buba, for whom I appear severally, Ibrahim Buba, and the tribunal judge. Both of them have exhibited courage. And this is why it is usually not in the best interest of any person to generalize the lackadaisical perception out there regarding judges. There are some of them who are not just steadfast, there are some of them who are courageous and are ready to interpret the law the way it ought to be and not the way it is. They, as judges, are in charge, in full charge. They are dominus litus, that is how we put it. They are in full control of the courts where they are. And therefore, you can make an order. The trial is not in secret. But please, for God's sake, I need a serene courtroom. One in which I will be able to concentrate and hear the advocacy coming from both ends for a just determination of this matter. And therefore, I am limiting the spectators in the gallery to just as much as the chairs they can take. Because what if it's a bizarre? And you could see that you could see that it's not taken seriously. People are thumping or people are passing words and people are completely confused about what is going on. So I am recommending, and it is within the prerogative of the judges to give that order. Once it's given, there are security agents to enforce that, in addition to what the people can do. And we're out of this crisis. Because the way it works is that I've told you it's a conspiracy of the ruling class. They have identified a hole in the ship. If it's not blocked, nipped the board, the tendency is that we're going to have a sinking boat.
Let me ask you, excuse me, sorry, take a look at this whole trial itself. I mean, you take a look at the drama we see, and whether we like it or not, the trial itself has actually not begun. Actually, it has not begun. We're still going back and forth, and we've been on this now for over 2 months, and the trial itself has not begun. And some people have said even lawyers themselves are not helping matters. But how do you see, I mean, how do you see, where do you see this going?
Well, the wheel of justice moves gradually, but steadily. When you have a good case, you have a good case. The reasons are obvious. The facts are sacred. The evidence are incontrovertible. The fireworks, the spanner that are thrown
by lawyers like yourself.
By lawyers. And you see, this is where NBA, National Judicial Council for Judges, should rise up to the occasion. Indeed, let me confess to you, and I'm saying this publicly, we are reviving some of the organs of the civil society that were already in place to take care of what these conventional bodies are not doing. You hear of NADL, National Association of Democratic Lawyers. And this is a body of lawyers that are not just progressive, but radically oriented, that are disposed to fill in the gaps. That body was created about the time when it became clear that our organization has been hijacked. And how do I mean? Cast your mind back from when it became the story that whoever emerged as the national president of NBA automatically becomes the Attorney General of the Federation. That way, we lost the potency and the capacity and the will and the zeal and the zest to deal with the core mandate of the organization. It was rampant during the military. Compromises were occurring at that level. And rather than pursue the objectives of the association, they were collaborating with the ruling class. And so the transmutations were not usually difficult. Organizations such as those emerged. Were playing the role of NBA, were playing the role of NJC, were playing the role of the Nigerian people. Those bodies we have to. You know why? Some of us have paid so much, including those who have died in the process, to ensure that we rescue some of these liberties that we have. And we're not prepared to yield the space because our children may not be interested in this process that we're taking. They could decide otherwise. And that will increase the security level in the country. So what do? First, we get to be conscious. We first have to appreciate that is a conspiracy of the ruling class. If you're able to deconstruct it at that level, first you understand what the issues are. Then you move to the next stage. They will continue to agonize or to organize to be able to tackle these issues. If we get to that point and we find that both the legislatures are ready to play ball in the sense that they now sit down like classroom students and learn and then move fast and legislate, you will leave it there. Otherwise, we activate the provisions of and it can be a campaign issue. Yes, it did happen. If the Nigerian people could rattle the ruling political party PDP to a standstill and prove that it is no longer given, and once you are the incumbent, you will, then any other thing can happen. We are not ready to toy with that.
Finally, I have to ask you this because, you know, we just don't know where this is
But please, before you ask, sorry, let me interject also. What do you lose if, one, you've refused to step aside, you know, to give honor to such events, and then face the trial and get vindicated? What do you lose? What impression are you creating?
Exactly what I was going to ask you. Why is it so difficult for the Senate President? Because he's actually come out to say those allegations are false, frivolous, and that they were basically calculated to rubbish him. Why not go there and then clear himself of all this mess? Why delay?
Let me tell you how it works. You remember my former governor, James Ononefebori? A 172 count charge was preferred against him here, reduced to 170. Eventually, before Honorable Justice Awokuleyin, he was discharged of all offenses. Lesser count charges were preferred against him based on the same facts and evidence
in the UK.
In the UK. They didn't go to trial. Please, mark my word. They didn't go to trial. What happened? The lawyers looked closely at the case, called him, sat him down, told him that if in the face of the body of evidence that is available to the prosecution in relation to the defense we think we have, is allowed to go in by way of trial without conceding, throwing in the towel, pleading through a plea bargain for a reduced conviction, then some of us lawyers will have to pay dearly. In short, some of them do have their their name struck out from the bar. That is a society where the sanctity of the profession is guarded jealously. Where you will come out and say, DG, I have looked at this whole thing. If I waste the precious time of the Queen and allow the state to deploy the resources meant for other infrastructural developments towards prosecuting an otherwise frivolous case, I will pay for it. I therefore advise you to take this option or take that option. That was James Ibori's case. In short, some of you journalists, very disturbingly these days, have asked me, what about outsourcing our criminal cases abroad? So that the only few we have seen are there. Ibori, later Alamesia, Dezani. Now, if you bring, in short, are you aware that Ken Nnamani is still under trial? Are you aware that
Joshua Dari?
Are you aware that Odili has in his kitty a perpetual injunction, never to be Are you aware that countless?
The former governor of Jigawa State, Saminu Turaki.
Turaki, all of them. So people are now saying, why not outsource this thing? But I have always taken a different position. That is, it's almost like handing over the security of the country to foreigners.
But you can understand the frustration of people.
Quite clearly. So this is the situation.
Well, it's quite unfortunate. We just wait and see where all of this ends. But honestly, it doesn't make sense at all that each time the Senate president has to go to the Code of Conduct Tribunal, the entire Senate will shut down business for the day. So for how long is this going to continue?
Where are the men of honor? Where is the distinction? They are called distinguished senators.
And something I don't know if you saw that.
Wouldn't we see men of honor who will stand out and say, come, young man, please face the music?
Isn't it some kind of irony that, you know, before one of the senators now, Senator Dino Melai, who is a staunch ally of the Senate president, before he became the Senate president, we saw him under former President Goodluck Jonathan, you know, carrying banner and campaigning for the removal of Stella Odua, who is now a senator. And the other day we saw both of them, you know, walking in tow in support of the Senate president.
Does that now reinforce my claim that it is a conspiracy of the ruling class?
Quite surprising.
It's a conspiracy.
Someone who was campaigning for the removal of another person over the issue of corruption.
I've not forgotten the presumption of innocence, but I've also tried to lay out other aspects of this whole trajectory and to expose, to show that we are exposing ourselves as a very funny society, one that can never be taken seriously in the Committee of Civilized Nations.
Malaki, thank you very much for coming on the program, and thank you very much for your wonderful contributions.
My pleasure.
Well, we'll take a short break now, and when we come back, we'll continue the discussion on another subject. Every day, every hour, and every minute, news break in Nigeria. Things happen so fast, it's most times difficult to track and comprehend them. But that's what we do right here on DEJI360. 2015, would you want to come back again?
It's like asking Jesus Christ if he knew he was going to die, will you want to come back as the savior of the world again?
We do not just help you track the stories, we break them down, explore all the angles, analyze the issues so that you can fully comprehend the stories and use them to make the right decisions.